It's my absolute pleasure to be presenting today on the AI Act and data protection, specifically what NGOs need to know. I want to kick this off by looking at bit at the AI as a phenomenon, as a challenge, as it presents itself for any organization, really. And that is first and foremost, I want to say the observation that it is not a single innovation that happens somewhere on the timeline and now we're all reacting to it. It is rather a continuous phenomenon. AI innovations keep getting made every day, and AI tools are becoming more and more powerful each month. And that means that it's not just a matter of reacting to the new reality, whatever it is, but rather as an organization, and also from a legal perspective as a lawyer, being agile in the sense that there is not just one piece of technology that we now have to get used to, but it is rather a journey that we're now on. There are many types of AI solutions that may not be fully practical just yet, but likely will be in a year. Intelligent robocalls, so effectively having an AI do something that a call center used to do. It's something that today is not really that practical since we already have the technology for it. The algorithms are there, the speech recognition, that's all working. That's something that could be implemented. It would just take too many computing resources for it to be economically feasible. That might change within the next 12 months. As the algorithms become more efficient, more powerful, in a year, it might indeed be a widespread phenomenon, even though it's not just yet. And just that's one tiny example. One area of AI where we're seeing particularly a lot of innovation happening right now is what's called agentic AI. So far, many types of LLMs that certainly from a consumer perspective, we have experienced effectively mimic human communication behavior. So these are pieces of technology that are able to communicate with us in a way that it's practically impossible to distinguish whether it's a machine or a human. What agentic AI is set to change is to not only mimic the communication behavior, but actually allow full process automation. That is, that you're not just speaking to an AI without maybe fully realizing that you are, but you're not just communicating with the technology, you might actually be triggering certain processes on the side of the organization that you're communicating with. So for example, somebody calls up an organization, raises a complaint. What an LLM can do is to formulate an answer based on information it was previously fed. That it can do. What agentic AI will be able to do is to trigger a response process within the organization, effectively automate business processes. And that will be a significant game changer. What so far we've seen is agentic AI systems being rolled out on the consumer side. You might have already seen, and it's going to become more prevalent in the next couple of months, mobile devices, etc., being shipped with personal assistants kind of AI systems that if you tell the AI to, it will do simple things like book a table for you, but fairly soon we'll be able to do much more complex things. And then to kind of have a bit of a midterm outlook here, the best guess in the industry right now out there is that within 3 to 5 years, we'll be reaching what's being discussed under the term artificial general intelligence, or AGI. AGI is an AI system that has cognitive skills that are at least as good as that of a human. And needless to say, that presents a number of challenges for our societies from a moral, ethical, legal, economic perspective. So going back to what I said at the beginning of the slide, we are not at an endpoint of an innovation. phenomenon. We are rather on a journey that will continue to present challenges. So it simply forces us to keep looking at how this develops. One aspect that we have seen in any organization, whether it's an NGO, a global multinational company, or a small Austrian company, adopting this new technology within your organization is a very separate challenge from realizing that it exists, that it is out there. Innovation being made is not the same as it being implemented in practice. What I always like to kind of cite here as an example, and something that we can definitely learn from, is the history of the steam engine. Does anyone want to guess when the steam engine was invented? It's actually about plus minus a couple of years, but it's the 1st century before Christ. That's how old the invention of the steam engine is. It took us until 1800 or something to reduce it to practice. The first patent is dated 1606, but the actual industrial application of the steam engine and the start of the Industrial Revolution is well until the 19th century. Why? Of course, there were a couple of technological innovations to build something as depicted here, but more fundamentally, and the point I want to make here is to find a practical application for an innovation is not the same as making the innovation. There are a number of steps in between. And I feel like this is where we are right now. Technology has been invented, but we haven't figured out yet what to do with it. I'm not saying by any means that it's going to take us 2,000 years. No, it's not. But I just want to reinforce the necessity for every organization to look at this technology and figure out what will this be able to do for me. And that is where the big challenge lies, and also the legal issues really lie. With that bit of introduction out of the way, as from a very bird's eye perspective, the two pieces of regulation, of regulatory areas we want to look at today is, on the one hand, the AI Act, the Artificial Intelligence Act, an EU regulation that attempts to regulate the phenomenon of AI. And on the other hand, an older piece of regulation, the General Data Protection Regulation, or GDPR, an EU regulation that regulates the protection of personal data. So it's trying to regulate privacy. It's effectively trying to protect personality rights, versus the AI Act, which tries to do that too, to some extent, but is mostly, as we'll see, mostly a piece of product safety regulation. The AI Act looks at AI systems, whether they're just software or embedded into hardware, as a product that presents certain risks and tries to regulate those risks. So looking at the AI Act, the first question, and that's really the first question that any organization should try to tackle if they're building an AI governance framework, is the question of, well, what actually is an AI system? What is AI system, as the AI Act refers to it, that is being regulated here? What we see way too often is an attempt to do too much. From an AI governance perspective, it is essential to make sure that whatever AI governance framework you're implementing, you're not trying to solve every problem in the organization that has to do with digitization. We're talking about AI, so let's make sure we understand what AI is. Unfortunately, the AI Act itself is not that much help here, because the definition you're going to find in the AI Act of what constitutes an AI system is extremely vague, and it turns my brain into a pretzel every time I read it. And it's a list of nonsensical terms thrown in together that more describe than define what it is that we mean. The only thing that truly helps us define what an AI system is as opposed to just any general piece of software is really examples that fortunately the AI Act itself provides, and it excludes certain types of systems. And there is really wherein the definition lies. It says that traditional software systems or programming approaches are not AI. Anything that is basic if-then logic that was coded by a human, that is not AI. On the other hand, novel technology that is not just if-then logic, that is what the AI Act is trying to regulate. So things like a large language model, a machine learning algorithm, or what's called the knowledge graph, basically a type of way to store data, to store knowledge in a kind of database that completely changes its structure whenever you put a new data point into that database. That's more or less what a knowledge graph is. So also a fairly novel piece of technology. All that are AI systems. If-then logic, on the other hand, is not. Even if it's highly complex software, if it's plain old traditional rule-based logic that was coded by a human being, then it's not an AI system. It might present other challenges, but it's not an AI problem. Just to make sure we know what it is that we're talking about. The AI Act in a nutshell is firstly trying to solve the problem of AI regulation by not treating every AI system the same. The AI Act is defining certain categories of AI systems and then regulating these categories differently. First and foremost, we have, as we'll look at in more detail, certain AI systems that are prohibited outright. Then we have AI systems that, in the legislators' view, constitute such a high risk that they should bear the vast majority of obligations that the AI Act provides. Then we also have, subject to quite a few requirements, so-called general purpose AI models. Here, the good news from a purely organizational perspective is only as the developer of such a general purpose AI model are you subject to any obligations. And in practice, no organization except maybe a handful of large big tech companies will develop such general purpose AI. So those part of the requirements you can more or less ignore. We can focus on prohibited AI systems and high-risk AI systems. As with anything that comes out of Brussels these days and takes itself seriously, the AI Act comes with heavy penalties of up to 35 million euros, or the case of organizations that do produce a turnover, there is a turnover-based fine up to 7% of that annual worldwide turnover. In terms of private enforcement, that is the ability of individuals that feel their rights infringed to take action, the AI Act has, compared to European privacy law, a very muted approach to this. And that is that individuals concerned do not have the right to participate in any kind of oversight complaint proceedings, as is the case under privacy law, not when it comes to the AI Act. Rather, what an individual can do is either go to court and file a civil action, which costs a lot of money, or to simply alert the authority, market surveillance authority in each respective member state, of an alleged non-compliance of any piece of AI. But then the authority gets to investigate that or not. In any case, the individual has no participation in these proceedings. That's from a purely risk perspective. If you want to look at it that way, it means fewer risks, because individuals cannot initiate free of cost a proceeding against you and then have a right to appeal any decision. That is not what the AI Act provides. In terms of timeline, the first obligations already kicked in as of February of this year. The prohibition against certain types of AI systems is already live. So is a general requirement that we'll get to in more detail to ensure that everyone using an AI system in your organization has a minimum know-how level when it comes to AI, has AI literacy. The vast amount of the other obligations, practically all that's relevant for NGOs, will apply as of August next year. So August 2nd, 2026, that's kind of the big deadline. Since we have in this call and people listening to the recording afterwards will have a number of participants from outside of the EU, let's look at the extent to which the EU AI Act might nonetheless apply to organizations outside of it. Here, basically, the AI Act adopts a market-based perspective. So, of course, any organization that is established in the EU is regulated, but also any what's called provider, any developer of an AI system, irrespective of where in the world they are located, is putting an AI system on the market in the EU. And that putting on the market can also be something that happens within a conglomerate of organizations. It can be as simple as one legal entity, let's say in the US, providing to a subsidiary in the EU an AI system. That too already constitutes an act of putting it on the market. It's also not possible to escape the application of the AI Act by effectively collecting some data in the EU, having the AI calculations done elsewhere, and then feeding back the result of those calculations back into the EU. That too lands the use of AI within the scope of the AI. So any non-EU entity that uses AI in a way that the output of that AI system is then used for purposes within the EU also becomes subject to the AI. So anything that is either sold to the EU in terms of AI systems or any use of an AI system where the benefit of that use is realized in the EU, all regulated. I also briefly mentioned before the role of a provider. That is indeed the most regulated role that the AI Act foresees. It's regulating a number of different roles, very much reflecting the fact that it is at its heart a piece of product safety regulation. So the roles correspond to what we know from EU product safety regulation in general, and that is very much mirroring the distribution chain of a physical product, even though we're mostly talking here about software. You have on the very left, you have the provider, that is the company that develops the AI system or buys the AI system from a third party as a white label solution and puts its own name, its own trademark on it, and then distributes the system. That too makes the company a provider. So if you're purchasing a third-party AI system and then are making it available under your own brand, even though you have not developed it, you will still be qualified as a provider under the law. So that's something to make a conscious choice of. The most important other role is on the other end of this chart, and that is the deployer. The deployer is the person, or typically legal entity, under whose authority the system is used. So think of Microsoft Copilot. Microsoft Copilot is an AI system that was developed by Microsoft. So Microsoft is the provider for that system. If you're deploying that AI system in your organization, then you're legally speaking, you are the deployer of that system. And that triggers certain obligations too that we'll get to. But those are the most two important distinct roles. Am I developing something, or have I purchased it that I'm slapping my name onto it and then making it available? Then I'm a provider. Or am I just running a system that I have procured from a third party? Those are the two important roles. Most organizations, and certainly most NGOs, will find themselves in the deployer role, I want to say 90% of the time. So that is the role, and we'll get to the specific deployer obligations in a bit, that is most crucial. In terms of risk classifications, I briefly mentioned before, we have the per se prohibited systems. We'll do a bit of a deep dive on in the next slide. Then we have the high risk AI systems, followed by the, for here, us more or less irrelevant general purpose AI models. And number 4, we have the limited risk systems. They don't even have a name under the AI Act. Those are most relevant for NGOs. Those are Gen AI systems, that is generative AI systems that produce content, images or text, or AI systems that even let the user to interact with the AI, like a chatbot. Those kinds of systems are very loosely regulated, basically only require us to make transparent the fact that the user is dealing with an AI system. In particular, a chatbot has to make clear that it is a chatbot. If we have an AI more or less perform the service of a call center, the AI will have to start the conversation by saying, I am an artificial person, I am an artificial intelligence, disclosing that it's not a real human being. Let's now look at the types of AI systems that are prohibited outright. And this is a selection that's potentially, at least remotely potentially relevant for NGOs. Basically, those per se prohibited AI systems are things that you feel in your very gut. Those are things you would not want to do. And very few organizations would get even close to doing these kind of things. So they're more or less no-brainers. But let's start with something that might not be that much of a no-brainer, and that is a biometric emotion recognition system that is used at the workplace or in educational institutions. So for example, there are, if you think about sales conversations or conversations, I don't think any one of you would imagine that as a good way to go, but I'm just saying there is technology out there that could allow you to automate the placing of calls to ask for donations and to track how those calls go by measuring the motion of the two people interacting in that call. There's technology out there that can do that, that can even automatically document in a cloud-based customer relationship management system like Salesforce, specifically what emotions the two communication parties had. That is possible today. It would, as far as it concerns the recognition of emotions of your own employees, however, constitute a per se prohibited system, which kind of makes sense that the EU legislator is saying we do not want employers to try to collect biometric data in order to figure out what their employees feel. That's nothing of the employer's concern. Obviously, also prohibited is trying to manipulate people in a way that ultimately makes it impossible for the individuals to realize that they're being manipulated. So what the law is not as clearly, but is ultimately prohibiting here is stimuli that you cannot perceive, like showing someone a short video that for the 20th of a second, so for just one frame, shows a picture that is, let's say, very, very gross, very ugly. We do, as humans, have an emotion to being shown that picture for the 20th of a second, even though we're not realizing that we've seen that picture. That type of manipulation is prohibited. Well, that would be prohibited under existing legislation anyhow, but here we have it too. The exploitation of an individual's vulnerability due to their age, disability, social, economic situation, that too is expressly prohibited by the AI Act. Again, something that law, as it already existed, would have prohibited anyhow. Those are the per se prohibited systems. Where it gets more relevant in practice are the high-risk AI systems. Sooner or later, you will be faced with the decision whether or not to deploy these kinds of systems. Biometric emotion recognition, as far as it does not concern your own employees, is not per se prohibited, but it is high risk. So if you used AI software to do calls to ask for donations, and that AI system, in order to simulate empathy, was trying to detect the emotion of the person that the AI system is calling, something that probably is the precondition for that kind of system to work effectively, that would be high risk, with the consequence that you would only be allowed to deploy any such kind of AI system if the AI system, you wouldn't be developing it yourself, that wouldn't be feasible. You would be purchasing it from a third party. If the provider of that AI system is effectively guaranteeing to you, in particular by having affixed a CE marking, a Conformité Européenne marking onto the product, guaranteeing to you that it has complied with all regulatory requirements. Currently, there is no such system out there that would do that and would have a CE marking. And remains to be seen whether the European market is interesting enough for such systems to be placed on the market. We'll see. Credit scoring too will be high risk. You might, depending on the size of your organization, in the vendor due diligence process or otherwise, might be doing credit scoring. Any kind of AI system that is used to perform credit scoring would also be high risk. I do want to flag that many credit scoring algorithms out there are not AI, are old math, not new math. And for that reason are not covered by the regulation. So it really depends on what kind of credit scoring algorithms use. The one area where every organization, every NGO will sooner or later be faced with AI is HR. Any kind of use of an AI system in the HR context, whether it's in the hiring phase or even the targeting of job ads, any kind of AI system that is used there, an AI system used to filter job applicants, evaluate candidates, or facilitate, somehow support a decision concerning the promotion or termination of an employee, or even the assignment of tasks to individual employees, all qualifies as high-risk AI systems. Those types of systems are being marketed quite aggressively out there, and sooner or later, there will be providers fully compliant with the AI Act that will offer high-risk AI systems in the HR space. And you will have to answer for yourself as an organization whether you will want to deploy these kinds of systems. For example, when it comes to the evaluation of candidates, there are aptitude tests. Many of those systems are ultimately machine learning based algorithms trying to help figure out what the personal strengths of a particular candidate are. And you would have a certain profile for a particular role in terms of leadership responsibilities, communication skills, etc., that you would want a candidate to have. And you can use a machine learning algorithm to help you figure out whether a candidate matches that profile. That is possible to do. Obviously, there are a number of risks involved here. At the same time, I do want to flag, and I'm speaking also as a partner of a global organization facing these challenges every day. If we have a purely human recruitment process, that is not a guarantee for a just outcome either. We all know that systemic discrimination is real, that unconscious bias among humans is real. So while we do have to recognize, I think, that AI systems present risks, we should not close our eyes to the fact that a purely human process presents certain risks too. In an ideal world, we will be able to, and pardon my optimism here, we will be able to use this new technology for the better. We will be able at some point to use this technology to very critically look at the kind of criteria that an AI system has learned to make an HR-related decision and to improve the quality of that decision so as to reduce the unconscious bias, the systemic discrimination that is very, very real in any large organization. That's the optimist in me speaking here. The last area of high-risk AI systems I want to flag is AI systems used to assess the eligibility for certain public essential services. That might be relevant for an NGO if it is providing these public essential services on behalf of a public authority. Depending the country that you're operating in, for NGOs in some jurisdictions, that is part of the operating model. Any kind of AI system that helps assess the eligibility, yes, would be high risk too. Let's now briefly look at what that high risk classification actually means. And as briefly hinted at before, here the law distinguishes between providers and deployers. I have here put on the slide a list of all the obligations that get triggered by a high risk AI system classification. Those requirements that are in bold and have an asterisk apply to both providers and deployers. The rest only apply to providers. And by that, you can tell that the vast majority of obligations only apply to the providers, not to an organization that is just deploying that technology. So what do we need? Well, a starting point, we need to figure out whether a particular AI system or particular system is an AI system or not. We need to identify the applicable risk category. And that very much depends on not only what is that technology, but coming back to my steam engine example, what is it that we're using it for? Because it's the usage, the purpose of the usage that very much defines the risk that is attached to that AI system. We also need a risk management system. The AI Act calls it. There are ISO standards for how risk management systems can look like. Those are management systems. So policies, processes designed to identify, assess, and manage risks. That is something we need to do for a high-risk AI system, even if we're only deploying it. When it then comes to the development of such an AI system, there is where the obligations get really, really heavy, starting with a quality management system. Some of you might know ISO 9001 that has been around for decades, but for AI systems too, we need something like this when it comes to the development of that system, starting with the training data, the data we use to train an AI system, to test, to validate the model. The data needs to be error-free, it needs to be complete, it needs to be representative of the population for which the AI system will be used down the line. So a great number of requirements that apply. You need to document everything, maintain the records, implement cybersecurity, perform a full assessment of whether the developed system then conforms with all applicable requirements. In some instances, that assessment has to be done externally with an independent conformity assessment body, a whole set of really organizational structure that has to be put in place in order to be able to lawfully develop a high-risk AI system. And that is why I said at the beginning, you will not be developing this yourself. The compliance burden that it creates makes it economically just not feasible to do this for your own use. If you're developing a system to sell it to a large number of other companies, other NGOs, okay, there might be a business case for it. But just in order to use it yourself, it does not make business sense. You would much rather procure that AI system from a third party, because that third party will have the economies of scale by being able to sell that AI system to a large number of players. So that is why in the high risk AI system space, development should be very, very low on your priority list, since rolling it out becomes an impossibility from a purely business perspective. It will cost too much. Once the product is launched on the market, you even need to register it. That also applies for deployers of high-risk AI systems. In some instances, have to register in an EU-wide database the fact that they're using a certain type of high-risk AI system. There will also be As part of any high-risk AI system that you purchase, there will be instructions for use. It's a manual, effectively, that you will have to abide by as a deployer. So that is, very practically speaking, something that's going to be important. You will be getting instructions for use for all AI systems that you purchase, and making sure that as an organization, you understand what these require you to do, and make sure everyone in the organization using the AI system follows those rules is really a requirement. When it comes to the deployment, one of the really key aspects I do want to flag here is human oversight. That also conceptually is key. The law asks us not to trust an AI system, certainly not when it comes to high-risk AI systems. It needs to be put under qualified human oversight. So practically speaking, you need a data scientist, someone with sufficient qualification in data science and statistics to be able to evaluate the performance of the system. Is it making correct decisions? Or to what extent is it making correct decisions? That's a critical aspect of lawfully deploying a high-risk AI system. Now, I want to very briefly zoom out a little and really look at the major components of an AI governance framework as you would implement it in an organization that will only be deploying but not developing AI systems, certainly high-risk AI systems. And that is, firstly, you would want to make sure that you have some kind of process in place that ensures that you are identifying an AI system before it is deployed. If you have very structured processes with a procurement team, then, well, that's the place to start. In many NGOs, that's not the case. Then you have to train your staff sufficiently that they know that they can't just use any kind of AI system that they feel like, but there has to be some kind of process that they're flagging internally. Hey, I want to use this. And then, as a second step, that the risk classification is done to figure out, in particular, is this a prohibited AI system? Unlikely to be the case, or more likely, a high-risk AI system. And if it is, do we have the necessary compliance components in place? And if not, then, well, we probably shouldn't be using that piece of technology just yet. Thirdly, you need, as an absolute basic bare bone component of an AI governance system, some type of internal policy guidelines that clearly lay out how AI systems are to be used within your organization. And ideally, it is a very short document. It does not contain a lot of wordy language. It's very precise on who does what, and what are the specific expectations we have of every member of the organization. It can be as simple for a small NGO as saying that we're not using any kind of high-risk AI system, and any other kind of AI system you want to use that is publicly available, feel free to do so, but do not put into that AI system any personal data, any kind of confidential little information, trade secrets, etc. And make sure that if you're generating any kind of content with an AI system, you're correctly telling people internally this is AI generated. That takes care of a lot of quality issues, takes care of certain copyright issues. It can be really bare bones. It doesn't have to be a 20-pager, but something needs to be put in place internally. And last but not least, ensuring a minimum amount of AI literacy. That is a basic understanding of everyone using this technology, how that technology works. So, for example, in the case of LLMs, that everybody understands that an LLM has no understanding of the content that it is producing. Ultimately, an LLM is throwing letters and words together due to certain statistical probabilities. That's what an LLM is. It does not understand the text it generates. That is the reason why it sometimes hallucinates, why it creates content that just makes no sense whatsoever. Once people have understood that, they will be able to use it more prudently. What is the output of that system? How can I make the AI system generate a higher quality output? It's the second kind of thing you would want to make sure everyone in the organization understands, starting with, I need to prompt properly, create a context, tell the AI system who I am, where I work, in order for the system to produce meaningful data. So that in very short, very practical are the basic build. Now looking at the privacy side of AI, firstly, and that's a bit of a technical question, I appreciate that nonetheless, it is an important technical question. The GDPR, General Data Protection Regulation, has two different basic roles, that of what's called a controller and that of a processor. The controller is the legal entity that decides what happens to the personal data. If you're deploying a certain piece of AI system, you are the controller. That is out of question. The big question is, and that is a very relevant one, what role does the provider play that is making the AI system available to you? Do they get to use the personal data that you put into that system for their own purposes? Or, and that is the role of a processor rather, as a processor, I'm only allowed to do with the data as instructed by the controller, as instructed by you. Therefore, what you would want is for the provider of your AI systems to take the clear compliance position that they're only a processor. Otherwise, it means that any data you're feeding into the system, the provider will be using to improve their system and do whatever else with that data. And that means the data is no longer your data. And that's typically something you would want to avoid from a privacy perspective and for many other good reasons too. If we look at the life cycle of an AI system more broadly, there are a number of privacy-related issues that arise in that life cycle, but I do want to break it down here to first the question of what is the justification, what is what we call the legal basis for using personal data in that way to begin with. Am I allowed to use personal data I might have collected over the last 10 years in order to train an AI system? The honest answer here is we're not 100% sure. And by we, I mean the entire European legal community, because the law isn't quite clear. If the law tells us if there is a prevailing legitimate interest to use personal data for a certain purpose, then we are allowed to. Well, is our interest to train an AI system prevailing over the interests of the people whose data we're using here not to have their data used? Well, that's a balancing test. And there are a number of court proceedings pending, mostly or exclusively against big tech companies, where that very question is being litigated. So it's going to take a couple of years for that question to be answered by ultimately the European Court of Justice. For now, the very practical answer I can give you is yes, you generally do have a prevailing legitimate interest, and practically all companies are taking that compliance position. Basically all are. So to the extent that as an NGO, you basically want to be where the larger economy is in terms of certain compliance positions. Yeah, for many AI systems, that means yes, you can use it to train your own AI systems. Subject to certain guardrails you will have to put in place, et cetera, but in principle, yes. When it comes to the use of the AI system, I also want to flag that there too we have certain impracticalities of the law. Under data protection law, we have what's called the principle of purpose limitation that basically dictates that we're not allowed to use personal data that we have collected for one purpose for another unrelated purpose. In the AI space, however, this is what we do, what any organization does. If you think about how Microsoft Copilot works, in Microsoft Copilot, all the data that an individual user has access to in the Microsoft Cloud environment, all emails, all documents on SharePoint, et cetera. Please. Akinola, may I ask to mute yourself? Super, thank you. Is effectively being copied in what Microsoft calls Microsoft Graph. That's a knowledge graph. And for every query you put into Microsoft Copilot, the system will use all the data you have accessible to answer each and every individual query. So effectively, all data gets used for all purposes. Is that lawful? I would say it's besides the point. Every organization does it. So practically speaking, it is. There will be no judge, no authority in Europe that would dare to rule against this, because it would mean killing the use of office productivity systems that contain AI. So no one will do that. In the interest of time, I do want to switch over to the use cases. And here it's not on me to tell you. I did bring a couple of thoughts, but really I do want to open it up for discussions, really, just to throw it out there. Obviously, office productivity tools like Microsoft Copilot, DeepL for translations, or the Copilot equivalent in the Google Cloud, Google Gemini, can do fantastic things, many fantastic things, with certain limitations that seem to get smaller every month. In the kind of business process automation space, whether it's the automation of calls, whether it's using large language models to sift through huge amounts of data that is published by governments to effectively research certain things, that's where AI can help. And really the big question for any organization, whether it's an NGO or a for-profit organization, how do we want to reimagine how we as an organization pursue our mission? And that's where the digitization part gets to a digital transformation. How could we rethink, reimagine how we're pursuing our mission? And that's something that every organization would have to look at individually, obviously. But that's kind of the big question. It's what we do. Will that still be what we're going to be doing in 20 years? I don't know. For my profession, I can certainly tell you it's going to be different in 20 years. But who knows for certain? And with that, I wanted to open up the floor for any questions you might have.
Yes. Well, thank you. And also some people are leaving in the chat saying thank you for the insight. We already have some questions. If it's posted in the chat, I would read them out loud. And otherwise, if you would like to raise the question yourself, you can raise your hand within the Zoom meeting. I hope that is okay. And also, because today we still have just a few minutes left, we would also invite you to stay a bit longer for the question and discussion, as I think this is actually very, very insightful. And thank you, Dr. Feiler. So the first two questions from Avani. You mentioned in the intro that one shouldn't try to use an AI framework to deal with all digitalization matters. This is something NGOs I work with often grapple with. Typically smaller NGOs. Should the AI policy be built into the general IT policy, or is it better to stand separately? Do you have advice on how to structure this most practically, effectively?
I would definitely make it a separate policy. And the reason for that is that AI is not just an IT topic. And if you make it part of the IT policy, that is how the organization will perceive it. Typically, you have stakeholders from really every part of the organization, not just from IT.
Okay, thank you very much. Second question, also from Avani, is could you share any insights or good practices you've seen in terms of internal consultation on the organization's policy and rollout of AI literacy training? Yeah, I also have a few things to say about this, but yes, Dr. Feiler.
Well, my view would be that, of course, very much depends on each individual organization, but those things are most effective where before rolling it out, you were successful in involving the necessary stakeholders and making this not just a top-down approach out of the compliance or legal department, but really helping the organization see AI not just as a compliance challenge, but as a broader governance challenge. So not only to look at it from a risk-based perspective, which unfortunately is what the law is doing mostly, but rather also from an opportunity perspective. Because only that, I think, helps the organization truly realize the potential of this technology while at the same time managing the risks that do exist adequately.
Yeah, thank you for your answer. And I would actually also add a little bit on this because practically, I think what you're speaking of is also what we are doing and or part of our mission at AI for NGO. I previously created this AI governance workshop and we introduced this simple adapted version of NIST AI risk framework. But using this framework, we look at both opportunity and risk, and also we consider ownership, and then we follow the map, measure, manage system, which I think is very important. And in the same time, we're also like trying to help with organizations with AI literacy training by also trying to make the use case and also the context more targeted for NGOs. And so if you're interested, we would also like to share some resources that we find very helpful. The next question from Benjamin. So if we implement an LLM on our own hardware for data protection reasons, we become a provider? Question mark.
Not necessarily. The fact that it runs on premise doesn't make you a provider outright. You either, to become a provider, have to have developed it yourself, or you have procured it from a third party and you're operating it under your own brand. But if you like Microsoft Copilot, to the extent it runs locally on your own hardware, you're still not its provider, because you have not put your logo on it. It still says Microsoft Copilot. So we adjust the.
I agree, and I think that is also a very good question. I would like to ask a follow-up question on this, just to see if my understanding is correct. So, because also we often see like in a technical implementation process, for example, we would consider like there's I would say a setup in which Microsoft Azure runs OpenAI or other open source model within EU. And so that's the data being transferred into the data center should be GDPR compliant because the data never left the EU and it's also processed within the GDPR framework. And in the same time, if there are database attached to or like not used to train this AI model, but attached and to exchange information in this setting. So we're not running any LLM on premise, but within a data center within EU. In this case, we're also not using this data to train the model. Are we both AI Act and GDPR compliant? I mean, AI Act, we still need to consider the use case specifically, but is my understanding correct in this case?
Yes, and especially what you described, using the data effectively to generate output. And it's called typically, I think you're referring to a retrieval augmented system, a RAG, is a very privacy-friendly way to do it. You're not training the algorithm, you're just using it to improve the output that the system produces for you. And to the extent you're keeping it in the EU, all the better. There are compliant solutions out there too. If you need to transfer it outside of the EU, but keeping it in the EU is certainly a safer bet.
Yeah. Okay, I understand. But on the other hand, if organization, for example, people using ChatGPT or from the US or DeepSeek from China, but then like so like normally this kind of off-the-shelf solution at this moment, we would not advise people to put any personal data because they are not GDPR compliant. Is that also that? Yeah, I would assume that's the case.
As regards DeepSeek, yes, I would have concerns. For US-based providers, legally speaking, at least we still have what's called an adequacy decision from the European Commission for the United States, which makes data transfers to the US so far. At time of this taping, legally a lot easier than, let's say, in China.
Mm-hmm. Okay. Thank you for your answer. We have another question from Akinola. How you see using AI for external communications of an NGO, like a bot?
To the extent that you're being transparent about it, it is lawful. And it, I think, can deliver value to ultimately the people you're trying to reach with any such communication. So there might indeed be a good reason for it. You would certainly want to think through how are the interactions with the chatbot being logged, or ideally they might not be even logged at all. So what kind of privacy concerns are you creating for users by having them interact with the chatbot? There you would want to put some thinking into it, but that is something that can be implemented also in a very privacy friendly manner.
Yeah, I guess context is very important, and also like I think the first point, transparency within the organization, and also communicating without or to the external, externally is also very important. More questions? Okay, another question from my side related to the high risk or risk categorization or classification, which I think is very interesting. So let's say that we leave LLM for a moment and looking at machine learning. A very classic thing is to do customer segmentation, and we've also seen some case study that NGOs use do donor segmentation. And within this kind of case, obviously we're using data we collected over the years, and then we extract features, and then we're trying to create such classification, and not necessarily credit scoring in this case. But would this be considered of high risk, or how would the classification would be?
It will ultimately not qualify as high risk. These types of segmentation or profiling activities do not fall into any of the high risk classifications. The only thing I do want to flag is we do have case law from the Austrian Administrative Supreme Court holding that to the extent that the customer segments that are being created, in this case donor segments, are so specific that they ultimately reflect a worldview, it constitutes the creation of what we call under the GDPR sensitive data. So if you're basically saying, oh, what I have here is a postmodern nihilist, and this is assigning attributes to groups of people. That is something that, legally speaking, you could only do with the express consent of the individuals concerned. So you would want to carefully look at the types of segments that you're creating and how they're called to make sure you're not running into a privacy issue. But it's not an AI, it's a privacy issue.
Okay, well, thank you for answering that. I think that clarifies a lot, because that has been, I would say, a longer standing question of mine. Do we have more questions from today's participants? If yes, you can still raise your hand or post them in the chat. Okay, if not, may I have one last question? Sorry, I'm full of curiosity, and also I think like the regulation at this moment is just so much uncertainty and unclarity, and I think this is the greatest opportunity that I've got so far. So previously you talked also a little bit about agentic AI and how its progress moving towards like full automation, where at this moment a lot of, I would say, based on AI Act regulation, we're still looking at keeping human in the loop. And also later on, you also talked about having a human oversight is incredibly important. And I wonder if you think at one point we would actually progress to this full automated progress of using agentic AI and still be compliant and make sure we have the oversight within the system. And also because like while we were talking about, I think the first very important thing is to help us to clarify what is AI. But there are, and then we said traditional code is not considered AI, but there are also agents that generates code at this moment. And so that is like getting very, yeah.
Let me
gray
unpack that, because there were two very interesting questions in there.
Yes.
The one is, what is rule-based logic that was not produced by a human, but by a machine?
Exactly.
Is that AI? And I would answer it that way if the machine that created the code was in itself an AI system, then yes. And provided that there is no manual review of the code that the AI system generated, then yes, the generated code, I think, likely would be qualified as an AI system, even though it's rule-based. In practice, so far, the code is still manually reviewed, often enough, not well enough, but it's still manually reviewed. So the way software is traditionally being developed with the help of AI as opposed to AI developing it on its own, it would not qualify as AI just yet. Yeah. The second question you had concerning, or actually your first question concerning agentic AI is very much spot on. The AI Act itself actually does not regulate agentic AI systems. It only regulates them to the extent that they qualify as high risk. And they would only qualify as high risk if for example, they're automatically assessing the eligibility for essential public services. But if they're doing something else, like in the corporate setting, deciding whether a consumer warranty claim is indeed justified or not, and accordingly automatically sending a new product to the consumer, that's agentic AI, but it's not high risk. What it is nonetheless tightly regulated under old law, if you will, and that is the GDPR. The GDPR is in many respects for these kinds of agentic AI systems, the true regulatory burden. The AI Act is more or less, has not foreseen that technical development, to be honest. But the GDPR has always, even going back to the data protection directive from 1995, has always put a very strict regulatory burden on these kinds of fully automated individual decisions, in the sense that any fully automated individual decision that either has legal effects or similarly severely affects an individual is, as a principle, per se prohibited. Now, only 3 exceptions, and that is the data subject's consent, the necessity to perform or conclude a contract, or a statutory basis under national law. In practice, you will almost in all cases, you can obtain consent, or you simply don't have a legal basis for it. So the big question will be, how can I get consent for the use of an agentic AI if, as an organization, I want to use it? This is among the reasons why agentic AI is so far mostly being deployed on consumer devices, on the consumer end. So from a regulatory perspective, the provider of the AI system is effectively saying, I'm not using it. The end user is using it.
I see.
They're responsible for it from a GDPR perspective. Whereas for an organization to use, let's say in their call center, an agentic AI, a lot trickier. You first need to get consent for it, which under the GDPR is, I don't want to get into details, but is a difficult undertaking.
Yes. Well, thank you for answering both of my questions. I tried to sneakily put them in one, but failed apparently. And yeah, great lawyer, of course, Dr. Feiler. Thank you so much for today. And also unpacking the difference and the interplay between GDPR and the AI Act. And to be frank, from my perspective, the more I work with and also understand GDPR, the more I find I respect how the system is set up, and how in a way also very complete, and it's a great foundation for creating any kind of AI regulation that is AI Act of today. Yes, many thank yous within the chat also. Yeah, Julia, do you have anything to say for today before I?
No, I am also very grateful, and I found this discussions very interesting. And I must say, I'm very grateful that, Lucas, you can explain quite the complicated topics in a way that I can follow it. I can understand and better how really to apply it. And yeah, and thank you for all guests and for questions and for being with us today. And I think, as you said, it's a journey. So I would think we can continue this journey together. Maybe next time we will meet somewhere when we have the next steps and would learn, open new questions for discussion.
Yes.